Hello, Michael. I hope you're well, and welcome to today's interview about the Criminal Cases Review Commission, or CCRC. Before we start, could you summarise the key points you discussed with Sean Parker last week?
Yes, Patrick. In the summer of 1991, I was a successful businessman. I was a millionaire. I owned lovely properties, including in London. I had built up an entertainments company called European Leisure from a value of about £200,000 to close on £100 million. I had a big stake in the company. I had a good reputation, and I was looking forward with confidence to an ongoing successful career. That wasn't to happen. In fact, what would happen was that I would spend the next 10 years in the nightmare world of the criminal justice system. And I would go to prison on two occasions for offences I had not committed. Let me briefly explain how that happened. An executive of the company, a director who had sold us a business called Michael Quadrini, who had, we didn't know this, but had a form for blackmailing people and fraud, wanted me to give him back the businesses which he'd sold the company for £6 million. He invented false claims, monetary claims, and tried to pretend that I should hand him back his entire estate of businesses. Obviously, this was impossible, apart from anything else, because we'd paid him £6 million for it. But he was absolutely determined, and he decided that he would destroy me, and he kept threatening that he would. And one of the things he did is he tape recorded me. He said for hundreds of hours, but in either event, he made tape recordings, to which I said, well, look, take these wretched tape recordings to the police. I've said nothing wrong. But he said, I've made you seem like a criminal. You'll be surprised what I've got them to say. So he took these tapes, or some of them, to the Department of Trade and Industry, and they listened to these tapes, and they told him, go away, there's nothing on these tapes that indicate that Michael Ward has committed any offences. That was, in theory, it, and that's what we believed was it. But 8 months later, mysteriously, the Department of Trade and Industry started an inquiry into me and reactivated this man's complaints. And what happened was that they fabricated evidence against me. This is the DTI. They lied when referring the file to the Serious Fraud Office. They lied about what I had done, and they withheld information. The Serious Fraud Office, upon receiving this file, lied and falsified evidence, including a tape recording. But what they also did is allow a national newspaper, the Mail on Sunday, to corrupt the entire Serious Fraud Office inquiry. The Mail on Sunday, in the guise of two journalists, Clive Woolman and Lawrence Lever, over the next 4 or 5 years, 6 years, committed multiple corruption. They bribed prosecution witnesses, telling them to lie under oath at my trial. They falsified witness statements of prosecution witnesses in return for more secret cash. They falsified a witness statement of their own, making up absolutely devastating allegations about me, which had been completely fabricated. They entered my house without my permission when I was abroad. They broke into my filing cabinet, and took away hundreds of documents which I was intending to rely upon in the proceedings. They destroyed them. They did this a second time a year later. This was a complete outrage, and they threatened defence witnesses, they leaked information, they perverted the course of justice. But astonishingly, despite numerous attempts by me to complain to the Serious Fraud Office at the corruption of its own inquiry, the Serious Fraud Office refused to do anything, to refuse to investigate or to stop it. So it carried on. The Serious Fraud Office process resulted in me going to court. On 2 occasions, I was charged, I was convicted and sent to prison. I then continued to complain to ministers, to even one prime minister, to attorneys general who are in theory responsible for the Serious Fraud Office and indeed for newspaper behaviour, and eventually to the Criminal Cases Review Commission. But absolutely none of them were willing to investigate the corruption, the wholesale corruption of the process, which had taken place in my case. And so I was obliged to reinvestigate the case on my own. And I did that. And I find some astonishing consequences. What I discovered was that I has not been the subject of proceedings based upon anything people felt I had done wrong. Proceedings had been triggered against me for corrupt political reasons by ministers and by Mohammed Fayed. They were working together on a matter completely unrelated to European leisure, in relation to an inquiry which Norman Tebbit had been involved in, now Lord Tebbit, in which I had given evidence against Mohammed Fayed, accusing him of lying to the British government about his purchase of Harrods. And to cut a very long story short, he had lied. I gave evidence to that inquiry along the lines that he had lied. I had had dealings with him. My estimate was he owned £20 million and not £600 million with which to buy Harrods. But when he learned about this, he became absolutely apoplectic with rage, decided to destroy me and destroy others. There were multiple other people Fayed decided to destroy. But the link with the Department of Trade and Industry was that they too wanted me destroyed because they wanted to overturn the findings of the House of Fraser report because Norman Tebbit was being sued by a company called Lonrho over his mismanagement of Lonrho's bid or attempt to buy Harrods. So to cut a long story short, I've discovered that I am a victim of a very serious miscarriage of justice, having nothing to do with any misconduct that I committed. All of it was fabricated. All the cases against me involved perjured evidence, falsified documents and tapes, but none of the authorities are willing or have been willing to investigate it, and I think it's an outrage.
You believe you've been the victim of a serious miscarriage of justice, and you blame the CCRC for this, at least in part. What have you learnt about the CCRC, and can you explain what they do?
Yes, when I eventually found myself going to the CCRC, I discovered that it was a profoundly dishonest organisation, and I will come on to that in a moment and explain what I mean by that. But the CCRC, in ordinary circumstances, performs a vital job for thousands of people who believe they are victims of injustice. What happens in this country is that if you have been convicted of a criminal offence and you have tried on one occasion to go to the Court of Appeal, and you've done that, but the Court of Appeal has refused to quash your conviction, then the only way you can get back in front of the Court of Appeal is to apply to the CCRC, the Criminal Cases Review Commission. And the CCRC's job is to look at what you've gone and what you've argued about. You have to have new evidence and or new argument. And if they believe there is a real possibility that if they were to refer your conviction to the Court of Appeal, there's a real possibility would overturn the conviction. And so to cut a long story short, there are many fantastic people who work at the CCRC, thoroughly honest people who do an excellent job. I'm certain of that. But what I discovered, and I'll come and tell you in a moment, is that it is, or at least it was in my case, an absolutely thoroughly dishonest organisation that perverted the course of justice.
Can you explain the real possibility test? And do you think it's a fair test?
Yes, the problem with the real possibility test is really that it is an unsuitable test for determining whether applicants should be entitled to take their convictions back to the Court of Appeal. First and foremost, you need to have new evidence or new argument. The CCRC will not even open your case and look at it if you don't present them with new evidence and new argument. That doesn't work because many people who are in jail cannot find new evidence and new argument, but are nevertheless innocent. They were wrongly convicted. And you would think that a miscarriages of justice organisation would give equal time to cases of people who have cogent arguments that they are innocent, but they simply haven't got new evidence and new argument. Another problem with the real possibility test is that it requires the CCRC to guess what judges of the Court of Appeal might do if they referred a conviction. The Court of Appeal doesn't have any confidence in the CCRC, cannot have, because it doesn't listen to CCRC's own views of the case. What it asks the CCRC to do is to decide what they, the Court of Appeal, would do. And that, of course, is a very limiting factor. And apart from anything else, it results sometimes in the Court of Appeal finding that a conviction is unsafe. But if you want to overturn the conviction completely on the grounds of innocence, there's a third test the CCRC has to apply, which is what will the Court of Appeal say about the case if we refer it, but not about us, but about what the jury may have said or thought. So in theory, the CCRC is asked to conduct, binary investigations into the thinking process of third parties over which it has no knowledge or consideration. It is an unfair test, which in my view is about control by judges. Judges who are no better or worse than the rest of society, they make the same errors as the rest of society, like to control things. They don't like to admit that the criminal justice system throws up lots of cases of miscarriages of justice. They don't want to allow too many cases to get through, because there hasn't been a miscarriage of justice in this country that hasn't already gone through the hands of a judge. They don't want to admit that. And so they've got this extraordinary test, which they apply in the particular way they choose to do so. That is not statute demanded, it's what they've determined. And I say it is entirely self-interest. They want to control the numbers of cases that get referred and which then get overturned to provide a fiction that the criminal justice system works very well when, frankly, it does not.
Have you applied to the CCRC for your convictions to be referred to the Court of Appeal? And if so, what has happened?
Yes, I first applied to the Criminal Cases Review Commission in 1999, 2000, and after 6 years, they decided not to refer my case. I have a lot to say about that in a moment, but to cut a long story short, they spent the entire time talking to themselves or other officials. They made no proper inquiries. But nevertheless, in 2013, I had a second go. I what's called reapplied to the CCRC upon new evidence and new argument. They weren't even willing to reopen my file. They came up with absolutely astonishing statements which were untrue, factually dishonest, and frankly amounted to sophistry. But they concealed the errors that had happened on the first occasion. And then more recently, in 2021, I reapplied a second time, i.e. this is my third application to the CCRC. It is in the course of being examined. I don't know very much about what is happening. They do not tell you very much at all, but I have no reasons at the moment for complaining about it because I don't know what they're doing. I don't think they're doing a great deal, but nevertheless, I await judgment on that.
The CCRC has faced a lot of criticism over the years, especially recently. Its former chairman, Helen Pitcher, was forced to resign. Can you explain why this is?
Yes. The CCRC has come in for a great deal of criticism over many years, and for a variety of reasons, really. In the first instance, a lot of complaints about the CCRC are related to their interpretation of the real possibility test. It is an unsuitable test. It is very hard for the CCRC to interpret what the Court of Appeal will think, because judges of the Court of Appeal themselves vary and have different thinking. And so they have come to be very restrictive in their interpretation of this test, and they're very frightened of the Court of Appeal. They've been bashed by the Court of Appeal into feeling very subordinate, not surprisingly, because the Court of Appeal isn't interested in what the CCRC think. They're only interested in what the CCR thinks they think, which is an extraordinary request. So many cases of deserved convictions being overturned have not gone ahead. And the most serious case of that in recent years is the case of Andrew Malkinson. There are probably many others, but Andrew Malkinson spent 17 years in prison for a rape he did not commit. And the cause of that was, amongst other things, the failure by the CCRC to conduct proper investigations. They didn't conduct DNA tests properly or at all. And so Andrew Malkinson, completely innocent of rape, spent 17 years when he would have come out years earlier if the CCRC had done their job properly. Bottom line is, the CCRC is not the organisation that Parliament wanted to set up. It has to apply the wrong test for the wrong reasons. It fails to properly investigate cases, but that is the situation that exists.
Are you saying that the CCRC didn't properly investigate your case in 2005 and 2014?
Yes, it is absolutely my case that in the years 1999 to 2005 and in the years 2013 to 14, the CCRC did not investigate my case either properly or at all. And I think your listeners would be astonished that journalists who had bribed witnesses, prosecution witnesses, and told them to lie on earth, that had stolen documents, breaking into my home when I was abroad, breaking into my filing cabinet, taking away hundreds of essential documents, falsifying witness statements, fabricating witness statements of their own, threatening defence witnesses. You would imagine that the CCRC would investigate this, because how can you have a proper criminal process if behind your back, in the course of an investigation, a national newspaper is bribing witnesses, telling them to lie under oath, stealing your documents, breaking into your home, and falsifying witness statements? But they didn't. CCRC didn't bother with it, couldn't see it as relevant, which is extraordinary. They also failed to investigate any other of my complaints. As a matter of fact, all they did over 6 years is talk to themselves or talk to other government officials or civil servant type people or people with in public bodies. But they didn't investigate the crime that was taking place in the course of the proceedings against me by third parties. People were lying. Prosecution witnesses paid were lying. They'd been paid money to lie by the Mail on Sunday. And you would have thought that the Criminal Cases Review Commission would be bothered about perjury and about these things, but they were not. And so that is what happened in my case. It was an absolute outrage.
You say you made complaints, but multiple bodies refused to investigate. So you investigated the case yourself. You discovered that you were the victim of a politically inspired case by the DTI and Al Fayed. Can you explain this?
Yes. As you have heard me say, the Department of Trade and Industry and the Serious Fraud Office and the police acted criminally, I say completely unlawfully, by allowing the Mail on Sunday to carry out the perversion of the course of justice by bribing officials, bribing witnesses, stealing my documents, and so on and so forth. But the truth is that they did allow these things to happen. They did nothing about it, despite my multiple complaints. I sent in incontrovertible evidence of what was going on, but the Serious Fraud Office couldn't have cared less, did nothing about it, because they wanted to win my conviction. They wanted me to go to prison and for their statistics to be enhanced. They didn't care about sending an innocent man to prison. That's not what they interpreted their job to be. They interpreted their job is to score victories, and that was a complete criminal outrage. So I took my complaints to prime ministers, to ministers, to attorneys general. The latter are responsible for newspaper conduct in the course of criminal proceedings. They're also responsible for the Serious Fraud Office. I took my case to other public bodies and to judges, but absolutely none of them were willing to investigate my complaints, which were all evidence-based. And so I was forced in the end, after many years of trying to get people to do the right thing, to reinvestigate my case myself. And I discovered, extraordinarily, that I was the subject of a political witch hunt. What had happened in my case, and I knew I had done nothing wrong, but the prosecutors knew I had done nothing wrong. What had happened is that the proceedings against me had not been triggered because of a belief I'd done anything wrong. They'd been triggered by ministers of the former Thatcher government who wanted me destroyed because of evidence which I had given to an inquiry called the House of Fraser inquiry into Mohammed Fayed's purchase of Harrods. I had given evidence against Mohammed al-Fayed in the sense that I didn't want to give evidence. I was asked to give evidence, and I merely told the inquiry team that, in my view, having known Mohammed Fayed, that he did not have £600 million with which to buy Harrods, that he had lied about it. I estimated that he had about £20 million, which was still an awful lot of money by my standards, but he didn't have £600 million and had lied about it. Now, when Fayed learned of my evidence, he went apoplectic with rage and decided to ruin me, to destroy me. And he did decide to do the same with other people. It isn't just me. He went after multiple other people. But what he did with me is he set his team at Harrods onto me. They conducted a lot of disgraceful things. They also broke into my house and conspired against me. Well, I can go into the details on another occasion. But Fayed ended up collaborating with Norman Tebbit and the Department of Trade in order to ruin me, because the Department of Trade also wanted the House of Fraser inquiry to be overturned because of the fact that they were being sued by Tiny Rowland of Lonhro. So to cut a long story short, I was not charged. Proceedings did not take place against me for anything I had done wrong. They were taken against me for corrupt political reasons by the Department of Trade and Industry, Norman Tebbit, and Mohammed Fayed.
You say you discovered more serious problems with the CCRC. Can you explain?
When I started to reinvestigate my case, I learned that the CCRC had also acted criminally in my case as part of a cover-up. What had happened is this. In 1999-2000, when I first applied to the CCRC appointed a man called Edward Weiss, who was a commissioner, to take responsibility for my case. And he appointed an outside consultant called Ian Henderson, who was a well-known consultant, a forensic consultant. And Henderson's job was to investigate the facts of my case. And it would be upon the facts of my case, as interpreted and as arrived at by Ian Henderson, that a later group of commissioners would decide independently, or so-called independently, whether to refer my case. Now, in the course of 3 years of me interrelating with Ian Henderson, week after week, month after month, hundreds of conversations. I would run around finding documents for Ian Henderson, sending him documents he asked for, answering multiple questions. Over those 3 years, Ian Henderson told me of a lot of his findings, and every one of his findings supported my case for a reference to the Court of Appeal. He even said words to the effect, "You didn't do any of this." And I was naturally delighted about these findings of Ian Henderson. But it isn't just to me that Ian Henderson mentioned these findings. On several occasions, he spoke to my solicitor, Lee Goldsmith, and my barrister, Andrew Trollope. And on one occasion, there was a meeting at Andrew Trollope's chambers between Andrew Trollope, Lee Goldsmith, acting for me, and Edward Weiss, the commissioner, and Ian Henderson. And at that meeting, at which I was not present, they told the CCRC team, told my barrister and my solicitor in detail of findings they'd made, including of a tape recording demonstrating that I had done nothing wrong. And all of these exculpatory statements made about my case by the CCRC were written down with a contemporaneous transcript by Lee Goldsmith. So every word, or most of the words, that Weiss and Henderson mentioned to these lawyers was written down. Quite separately, on another occasion, Henderson had spoken at length to my solicitor Lee Goldsmith about believing that a policeman had been corrupt on the inquiry. He was going to go to the police misconduct department and have them interview this man Martindale, this crooked policeman Martindale, under caution. The next day he went and talked to Lee Goldsmith, confirming he'd just done that. This again was mentioned. But at the end of the process, when extraordinarily my case was not referred, and I asked Henderson and Weiss, what about all these statements you made that were exculpatory of me? Where are they in your findings, in your statements of reasons? And what about the things you said to my barrister and my solicitor? Where are those? Well, they could have said, we've revised our opinion, but they didn't. They lied. They barefaced black lied. They denied having ever said any such things to my barrister and my solicitor. So what the CCRC were expecting me to do is to distrust my own barrister and my own solicitor. The CCRC was asking that I believe that over 3 years, my barrister and my solicitor had lied to me and had fabricated meeting notes. I ask your listeners, can you think of anything more outrageous, more cruel than this country's miscarriage of justice organisation requiring an applicant, a desperate applicant, an applicant who knows he's innocent, demanding him to believe that his own lawyers had lied to him and had fabricating meeting notes. So essentially, the entire process in 2000 through to 2005 had been a corruption caused, in my judgment, at the time, by the independent commissioners, and Weiss and Henderson, in my judgment, I don't know for fact, had been prevailed upon to lie. Either they lied because they were happy to lie, or they lied because they were persuaded to lie. Either event, they lied. Barefaced, black lies, and the rejection of my case was corrupt.
You claim the CCRC lied and falsified documents during its investigation into your case. Do you have documentation to prove this very serious allegation?
You asked the question whether I've got documentary evidence of this corruption by the CCRC. The answer is I have multiple documents. It is simply inconceivable that anyone honest looking at this would consider that I was either lying or didn't have documents to support what I'm saying. I have not once lied. I'm telling the truth. I have document after document after document, and amongst them are the documents sent to me by my barrister and my solicitor. Why should I believe, just to help the CCRC hide and cover up official misconduct by judges and by officials of the Serious Fraud Office, why should I have to be believing that my barrister and my solicitor lied? They didn't lie. They told the truth. I have documents to prove it. So the answer is the CCRC can, under no circumstances, consider I've lied. If they do so, you can imagine that I will continue to go after them.
You say in a July 2021 phone call, former CCRC consultant Ian Henderson told you that your 2005 application was refused for political reasons. Can you explain this?
Yes. When I was deciding to reapply to the CCRC a second time, by that I mean to launch my third reapplication or my third application, I decided that I would complain yet again about its perversion of the courts of justice by the lies told by Weiss and Henderson, and also by the hiding up or lies told about everything I had been told. I wasn't prepared to live with it any longer. And so I telephoned Ian Henderson. I had not spoken to him for 13 or 15 years, but I found his number and I telephoned him. And he was perfectly happy to talk to me. And I recorded the conversation. And he told me that he had sat down in 2018 with a journalist from the Guardian newspaper. Well, that shocked me because in 2018, I had convinced a journalist called Simon Goodley of the Guardian that my case amounted to a miscarriage of justice. And Simon Goodley had endorsed most, if not all, of my arguments. But Ian Henderson went to Simon Goodley and showed him a document which I had never myself seen, and told Simon Goodley to drop his publication or proposed publication, and that I was a liar. This was a complete outrage. But I didn't know it at the time of my call. I discovered that later. But in the course of my call, Ian Henderson told me that my case or my application in 2000 to 2005 had been rejected not because of any weakness in my arguments, but for political reasons. What had happened is that I had discovered that a founding commissioner of the CCRC, a man called John Knox, who was appointed to be one of the very first ever CCR commissioners, but had in the past been deputy director of the Serious Fraud Office, had lied when mismanaging an investigation into my complaints about the Mail on Sunday. John Knox had pretended to have investigated the Mail on Sunday. He hadn't. He lied about it. And he wrote to the Attorney General telling lies, effectively telling the Attorney General that he'd conducted a very rigorous investigation and there was nothing to my complaints. John Knox was a liar. The CCRC knew that a founding commissioner was a liar who'd contributed to a miscarriage of justice, but they weren't willing to admit that. So they found against me. They whitewashed John Knox, one of their colleagues, one of their friends, and they found against an innocent applicant whose only crime was to have discovered wrongdoing by public officials. Judges came to their rescue. Judges were no more straightforward and honest as were the CCRC or the Serious Fraud Office or the DTI. And so, to cut a long story short, that is what happened. And Ian Henderson admitted that, and I'm grateful to him. But the truth of the matter is that he did, along with Weiss, himself lie, he must be held accountable for the lies he told and for perverting the course of justice, and I'm hopeful that that will happen. I'm not expectant because I have no faith in the CCRC. I don't know anybody who would, been through my experiences, who would have any faith in the CCRC. You cannot have faith with an organisation, even if the overwhelming majority of people in it are honest people, excellent people. I'm sure they are. I've nothing for praise for so many of them and for the wonderful work they do. But the truth is, if amongst them a commissioner can lie and lie to a court, lie in documents for a court, and lie about an applicant, and if his consultant can lie and admit later that the applicant was rejected for political reasons yet again, this is an outrage. No one can have any faith in what the CCRC says or does.
What you've said about the CCRC are very serious allegations. It seems that the CCRC cannot be trusted. Have you alerted the authorities about this? And if so, what have they done?
Yes, as I said, I applied for the third time to the CCRC on the 21st of November 2021. It's been 3 years or more since that inquiry began. They don't tell you very much. They tell you practically nothing. But the one thing I do know is that upon receiving my complaint, the case review manager at the CCRC took interest in my complaint about the lies which Henderson and Weiss had told my barrister and my solicitor, and indeed me. I say lies, not lies in my case, but the fact that they were concealing the truth of what they had told me. So they reached out to Ian Henderson, their former consultant, who by now had become quite famous on another case, and they sent him details of my complaint, which made reference to the evidence I have. And Ian Henderson had said to me on this earlier call, make a complaint about all this to the CCRC, and I will cooperate fully with any investigation. So the case review manager had every reason to expect that Ian Henderson would cooperate. But having read my complaints, Ian Henderson, the former consultant, refuses to cooperate.
Have Edward Weiss and Ian Henderson agreed to assist your case?
I just mentioned that Ian Henderson, the former consultant to the CCRC, who spent years investigating my case, has refused to cooperate with the CCRC's current examination. One thing I have learned since applying for the third time in November 2021 to the CCRC is that upon receipt of my application, the case review manager took an interest in my complaints about Henderson and Weiss, and he passed to Henderson my complaints, my reapplication document and various other documents. I don't know whether he did the same to Weiss, that I don't know. But he said to Henderson, you've agreed to cooperate with this inquiry. Well, here is my inquiry. Can you please tell us what your views are about Mr. Ward's complaints? And Henderson, contrary to his undertaking to cooperate fully with the CCRC, is now refusing to do so. Henderson is an experienced expert. He gives evidence to courts of law. He's regarded highly. He's done some very good work on another unrelated case. But the truth of the matter is, he lied. He agreed to lie or did lie. Well, did lie, but he might have been prevailed upon to lie. But one way or the other, he has caused me untold damage, as indeed has Weiss. They lied about what they had told my barrister and my solicitor. They demand that I believe my barrister and solicitor lied to me and falsified documents. That is a total outrage. Now, as for what other complaints I've made, I've written to judges, to attorneys general, to ministers, miscarriage of justice organisations, pressure groups, all kinds of people, and not one of them have been willing to do anything. Most recently, I've written to Shabana Mahmood, who is Justice Secretary. I wrote to Carl Turner, who was before then Attorney General. I've sent letters to Lord Leveson, who didn't bother to reinvestigate my case either, notwithstanding his requirement to investigate newspapers. I've written to the judges of the Court of Appeal that mishandled my case in 1997, and I've written to the judge who refused to agree with my complaints in 2005 at a judicial review, and who sided with the lies told by Weiss and Henderson, and who required me, just as Weiss and Henderson had, who demanded of me that I believe that my lawyers, my barrister and my solicitor, both people of utmost probity, in whom I have utmost confidence, required me to believe that they were liars and fabricated meeting notes. So with that rather miserable end conclusion, the truth of the matter is I am a victim of a grotesque miscarriage of justice, not because of anything I've done wrong. All the evidence given about me or against me was fabricated evidence, bought with bribes, secret cash bribes. The documents were fabricated. Tapes were either highly edited or fabricated, including by the Serious Fraud Office in the case of a transcript. The entire system, criminal justice system, from start to go, has been shown to be dishonest, profoundly dishonest in my case. And I'm a victim of a political process, which I hope on this occasion the CCRC will recognise, but I don't know. What you can be certain of is that I will keep fighting. I'm 77, it won't change my life, but it may change the life of other people who are languishing in prisons for offences they did not commit. I care about them. They probably don't have the same stamina or whatever it is I may possess after 30 years of fighting. I'm still at it, but not everyone can do that. And so I hope that the complaints I make will be taken seriously eventually, that there will be a judicial inquiry or some other inquiry into my case, because what has happened is a scandal, and no one can have any faith in the criminal justice system of our country as things stand today. Thank you very much.
Thank you for sharing your thoughts with us today, Michael. That's the end of the interview. Thank you.